In most cases, the entire Chapter 7 bankruptcy process consists of completing the official bankruptcy forms, filing them with the U.S. Bankruptcy Court, and attending a 3 to 5 minute meeting with a bankruptcy trustee. Creditors rarely attend the meeting, and no attorney or court hearing is required in most cases. I'll briefly go through each official form that's required to file Chapter 7 bankruptcy. You can hire an attorney to fill these forms in for you, or you can fill them in yourself. The first form is the voluntary petition. The first thing you do is select from this drop-down. You would select whichever court district that you're filing in. And it's got all the court districts for the entire country on here. I'm using the Quick File Automated Bankruptcy Form software. Every bankruptcy court in the country uses the same official bankruptcy forms. So I'm going to select the Central District of California in this example. And when you select that, it'll automatically take that court district and insert it throughout all of the forms. So you don't have to keep typing it. It'll do the same thing with other redundant data too, like Chapter 7 or all this other information. The next thing is the case number. If you have not filed bankruptcy yet, you just leave that blank because you don't have a case number. Here where it says chapter you are filing under, you just select the chapter of the bankruptcy code under which you're filing. Chapter 7 or Chapter 13 normally would be the two chapters, the primary chapters that are filed by individuals. So in this example, I'm going to check Chapter 7. It'll ask you for just basic information about yourself, your name, any other names that you filed, any other names that you've used within the last 8 years, the last 4 digits of your Social Security number or any federal individual taxpayer identification numbers, also known as ITN numbers, that you've used, if any business names and employer ID numbers that you've used within the last 8 years, if any. If not, you just check this box saying that you haven't used any. The address where you physically reside and the county. And right here, this is for any optional mailing address. If you don't get mail at your home address, you listed here your mailing address, and that's where any mail from the bankruptcy court will go, to that, your P.O. box or whatever additional address, alternate address that you put as your mailing address. And here you just check the top box indicating that you've resided within this bankruptcy court district for the majority of the past 6 months. And it'll ask you again, are you filing under Chapter 7? You select the chapter, and if you're using automated software, you don't have to do it again. It'll already be checked. It'll ask you 2 or 3 times which chapter you're filing under. How will you pay the filing fee? Every bankruptcy court in the country charges a $335 court filing fee for a Chapter 7 bankruptcy. You can pay that fee to the court in full at the time of filing, or if you're not able to do that, you can fill out this form here called Application for Individuals to Pay the Filing Fee in Installments, and we have that form included here in these forms. It's down here, and we'll show it to you. And I'll show it to you in a minute. So you would apply to pay it in installments. Most courts will let you pay it in. They'll split it up into 4 monthly installments. They'll still file your bankruptcy now. It'll be effective immediately upon filing, and you just send in a payment each month to the court until you get it paid off. Just make sure you don't miss a payment, because if you do, they will dismiss your bankruptcy. You have to start all over again. The third option is if your income is not more than 150% of the federal poverty level for your family size, then you can fill out this form. It's called an application to have the Chapter 7 filing fee waived, and we have that form included in the software as well. And if that's approved by the court, then that will save you $335 if the court waives the filing fee. Next thing, it'll ask you, have you filed any previous bankruptcy cases within the last 8 years? And you just fill out yes or no and fill out the previous case. You'd list it if you have the previous case number, when you filed, all that. Otherwise, just put no. Are there any bankruptcy cases currently pending by a spouse or a business partner or affiliate? Yes or no. And it'll ask you, do you rent your residence? Yes or no. And it'll ask you if you have an eviction judgment against you. If you rent your residence and you have an eviction judgment against you, then you would check this box here, yes, and you'd fill out this next form right here, which is called Initial Statement About an Eviction Judgment Against You. And you see this form is watermarked. It says not used because it's very rarely used unless you have an eviction judgment against you. If you do, you have to list your landlord's name and fill out the information in. And if you have a judgment against you in an eviction proceeding, then you can fill out this form and you can deposit 1 month of rent with the bankruptcy court. It'll stop the eviction. If you if you're being evicted but there's no judgment for possession entered against you yet, the case is still pending, then you don't need to fill out this form, and the bankruptcy will automatically stop the eviction. without having to fill out this form and without having to deposit any rent if you're being evicted but there's no judgment yet. So this form, like I said, you fill it out if it's applicable. Next form is Schedule AB. Schedule AB is property. If you own any real or personal property, then you'd list it here. Real property, of course, is real estate. Personal property is anything that you own other than real estate. It could be a patent, a trademark, furniture, bank account, anything, jewelry. So Part 1 is real estate. If you have any real estate, then you'd list it here and the value. And keep in mind, this is not a complete instructional video. This is just basically a short video to give you some information about what's entailed in filing and preparing your own bankruptcy. When you purchase the Quick File Bankruptcy software, there's a very detailed instructional video that'll take you through all these forms with a little more detail. Part 2 is vehicles. If you have any automobiles, cars, trucks, and motorcycles, then you just list them here and the value. Basically, if the car's worth $11,000 and you own one half of it, if there's someone else on the title, then the value of your portion would be half of that. So if you own the whole thing, then it would be $11,000 if you own the whole thing. So you check this box to claim it as exempt. When you claim property as exempt, basically you get to keep that property if there's a law that says that it's protected from creditors. Exempt property is basically just a list. In every state there's a list of exempt property. That it's basically just a list of stuff, assets that the law says that creditors cannot take from you. Even if they sue you and they get a court judgment, there's a list of stuff like your house, like your primary residence. You have a homestead exemption that protects all or a portion of the equity in your home from creditors. And same thing, when you file bankruptcy, those exemptions normally apply as well in bankruptcy. And they're usually based on state law. There's a few states, about 14 states or so, that allow you to use what's called the federal exemptions. But in most states have opted out of the federal exemptions in bankruptcy, and you have to use the state law exemptions. Jewelry, furniture, appliances, just about everything that you own is exempt in most Chapter 7 cases. And if there's not a specific exemption or a law that says you get to keep something, like a bank account or something, usually they have a wild card exemption in most states that'll let you have, say, $2,000, $3,000, $4,000, a wild card that you can use to exempt and protect and keep anything that's not already specifically exempt. So you just check this box here, and that will transfer all this information to another form called Schedule C, Exempt Property. So you don't have to retype it all. So you list automobiles here, and then on Part 3, it would be household goods and furnishings, first category. Basically, you just list the big stuff in your house: 2 couches, recliner, coffee tables, appliances, just the big stuff. Not every little thing in your house you have to list. You just estimate the garage sale value. In most bankruptcy court districts, you don't even have to do this. You can just put various household goods and furnishings at residence and just estimate the value. You check the box over here to claim it as exempt. If you don't own any property in a particular category, then you just check the box that says no. I would say probably 5 or 6 or 7 of these things are applicable to most people, and most of them are not. So you'll probably be going through here just putting no, no, no most of the time. Electronics, if you have any TVs, DVD players, desktop computers, or any kind of computers, printer, cell phone, just estimate the value. Not what you originally paid for it, but what you think it's worth now. Just estimate it, claim it as exempt. And it's pretty simple stuff. You don't have to go to Harvard Law School to fill this stuff in. You don't have to pay $1,200, $1,500, $2,000 for an attorney to fill these forms in. You can do it yourself. If you can fill out a detailed credit application or a mortgage application, you can fill this in and do your own bankruptcy. Clothing, you just put various clothing and the estimated garage sale value, claim it as exempt. Jewelry, you don't just put jewelry. You have to put some kind of brief description of the jewelry: gold ring, silver necklace. You can put various necklaces or whatever, and just put whatever you think it's worth now, currently, and check the box. And you've got various different sections here. This is for bank accounts. You put the last 4 digits of the account number and the balance in your account as of the date that you file bankruptcy, and you claim it as exempt. And if you have mutual funds, bonds, stocks, all that kind of stuff, there's categories for that. If you don't have it, just check the box saying no, you don't have it. This would be 401ks, retirement accounts, any kind of qualified retirement account is exempt in every state under federal law, even if you have $1 million or more in there. It's there's usually no limit, unless certain types of IRAs may have 1.1 million or something, but for the most part there's no limit, and you get to keep all of your retirement account. And you have to list it on here, but still you get to keep it. So you fill all that information out, which is pretty simple, and then you go to Schedule C. You check this green button here to fill it in automatically, and what it'll do, it'll take all the data that you just typed in, and it'll automatically fill it in for you. It'll put the exact line number, where that property appears on the previous form. It'll put the description, the value, all that information will be filled in, and then you just fill in the exemptions, which we'll provide for you, and those are pretty simple to fill in as well. And here's the rest of all your data. So most of this will be filled in automatically, which will save you a lot of time. Schedule D, like David, this is creditors who have claims secured by property. Basically, if you have a mortgage or a car loan that you owe money on, anybody who has collateral, if you miss a payment, they have the right to repossess something or foreclose on something, then they're a secured creditor, which is usually your mortgage or car loan. So here you just list the mortgage company if you have a mortgage, and you describe the collateral, your residence, and you list the amount that you owe on it and the value of the collateral, and you've already listed this property on the previous Schedule AB form anyway. So you just fill that in. If you have a car loan, you do the same thing, list the value of your car and the balance that you owe on it here, and it'll do the math and do all that for you. The next form is Schedule EF, creditors who have unsecured claims. Unsecured claims are claims that are not secured by collateral. They're unsecured, like credit cards, medical bills, payday loans, old utility bills. There's no collateral for that type of stuff, so it's called unsecured claims or unsecured debts. And the first part of this form, Part 1, is priority unsecured claims. Priority unsecured claims in a consumer case is usually state or federal income taxes, or any kind of income taxes that is legally not dischargeable. You cannot get rid of it because it's either the taxes are recent, they're less than 3 years old. If they're over 3 years old, you can wipe out income taxes, state or federal income taxes. You can wipe them out just like any other debt on a bankruptcy. But if they're over 3 years old, or even if they're over 3 years old, you did not file a tax return for that tax year at least 2 years before your bankruptcy filing, or if you've never filed a tax return for that tax year, then that's a priority debt. You cannot discharge it. So unless you wait, file the tax return and wait 2 years to file bankruptcy. The other type of priority debt in a consumer case would be what's called domestic support obligation, which would be alimony or child support arrearages. Not ongoing child support, your monthly payment, but past due arrearages. If you have any of that, you list it here. These types of debts, priority debts, you still have to list them for informational purposes, but they are priority. Priority debts are usually not dischargeable. You can't get rid of them even though you have to list them. So you list them here, if any, or you just check the box saying you don't have any. A lot of people don't have priority debts. So it has a continuation sheet there. It'll say not used unless you fill it in. And Part 2 is any non-priority unsecured claims. And a lot of this may seem a little complicated, but when you think about it, it's really simple stuff. You either have the debt secured or it's not secured, and it's either priority or it's not priority. So this non-priority unsecured claims would be virtually every other debt that you have. That's if it's not secured by collateral and it's not child support or alimony or taxes that are less than 3 years old or don't qualify for discharge for some reason, then you would list it here. This would be like credit card debts. You list the name and address of the creditor, the last 4 digits of the account number, when the debt was incurred, which you can leave blank if you don't know, or just estimate, and the balance that you owe on it. And if you don't know how much you owe, you just estimate it. It's going to be wiped out anyway, even if it's incorrect. You just estimate as much as you can, which a lot of this you can get off your credit reports. Credit cards, medical bills, old utility bills, any deficiency balances that you owe on a car loan where the car has been repossessed. Originally, a car loan would have been a secured debt, but if they've repossessed the car, or the car has been stolen or crashed and totaled, now it's an unsecured debt because there's no collateral existing for it anymore. They've already got it back, or it's destroyed or doesn't exist. So it would be an unsecured debt. So you'd list here, and that'll wipe that out as well. Payday loans would be listed here. What else? You would list bank overdrafts. Those will be discharged as well. Just about any debt that you want to put on here that's unsecured, non-priority. And by the way, even student loans you list here as a non-priority unsecured claim. Student loans are normally not dischargeable. They're not a priority debt. A lot of people think they're priority debts. They're not priority debts. They're just non-dischargeable debts for the most part. There's very rare cases where you can get rid of a student loan. You can apply, and the court can say, well, it's a hardship for you to repay it, and the court can grant you a discretionary hardship discharge on a student loan. But in most cases you can't, but you still have to list them anyway, just for informational purposes. So now Schedule G. Schedule G is executory contracts and unexpired leases. An executory contract is like a health and fitness club contract, where you have like a 2 or 3 year contract, or 1 year contract with a health and fitness club, or like a cell phone contract where you've signed like a 1 or 2 year contract, and you can file bankruptcy and you have to list it on here, and you'll have the option on another form later on. You'll have the option to assume that contract and keep it in effect, or you can reject it and it'll wipe out any further liability that you have on that contract. It'll just be canceled out. And you can do the same thing with any unexpired lease, like an apartment lease, a house lease, an automobile lease. You'll list those here as well. You just list the name of the party to the contract here. You list the name here, and the name of the other party to the contract, and you put, like, describe what it is, like 48-month lease on Toyota Camry or something, and you can keep the lease or not, whatever you choose. Next one would be co-debtors, Schedule J. If you have any co-signers or co-debtors on any of your debts, then you'd list their names here and the name of the creditor. Otherwise, you check the box saying you don't have any co-debtors. Schedule I is your income. This is your current monthly income, and you would basically just estimate it, what your monthly income is. The first part, it'll ask you if, are you employed or not employed, and your occupation, and the name and address of your employer. Your employer is not going to be notified of your bankruptcy. It's just listed for informational purposes unless you notify them. If you have a wage garnishment or something, you may have to notify your payroll department of your bankruptcy to stop the garnishment. But other than that, nobody's going to notify them. Then down here, you'd estimate your gross monthly income. Line 2 is your gross monthly wages. You just estimate how much you make in a month, but your gross before they take out anything. That would be before they take out any payroll deductions. If you have any overtime, then you'd list it here on this line, and it'll basically give you your total income here. And all of this, this QuickFile software will automatically do the math as you're typing in. So right here is your payroll deductions. You just estimate your payroll deductions. Tax, Medicare, Social Security, insurance, 401k, whatever comes out of your check, you just fill it in here, and it'll tell you your net right here automatically. And then down here is any other income that you have. If you have any other income, like rental income or business income or unemployment or any other income, pension, retirement, you list it here in this section. And any income that you receive from the Social Security Administration, whether it's disability or it's retirement, if it comes from the Social Security Administration, then you still have to list it on this form. But there's another form called a Chapter 7 Statement of Current Monthly Income, which is part of the means test calculations. On that form, by law, you do not list any Social Security, but you do have to list it here on this form. Any income you have to list here. So it'll automatically do all the math calculations. It'll tell you how much you have left over, your net income right here. And then the next form, which is right here, just to show you, it's Schedule J is your monthly expenses. And basically, you just estimate how much how much your monthly expenses are in a month. The first part, it'll ask you if you have any dependents. And you don't list the name of the dependent, like, Susie or Bob, or you just put the relationship, son, daughter, whatever, their age, and do they live with you, yes or no. And if you don't have any, you just put no, if you don't have any dependents. And then down here, it'll ask you for your monthly, your line 4 here is your monthly rent or first mortgage payment, either one. You list it here, and it says here, if not included in line 4, if it's not already included in your mortgage payment, then you would also list your real estate taxes and property or homeowner's insurance if it's not already included in your monthly payment here. So here, you just estimate your monthly expenses. Down here, it'll say any other mortgages. If you have like a second mortgage or any other mortgage payment, you'd list it here. utilities, electric, water, sewer. You just estimate to the best of your ability your monthly expenses for these living expenses. Food, housekeeping supplies, child care, clothing, personal care products like Mr. Clean and doing your nails, laundry, all that kind of stuff you list here. And there are some guidelines, for maximum expenses for like food and certain things. And you can look at that. We will provide those to you, and just make sure that your food, like for a family of 3, it'll say you're allowed, $600, $700 of food, for example. And you just make sure you do not exceed those maximum amounts. Your car lease payment here. And then if you have any other real estate, if you have a second property or something like a rental property, you'd list it here. The expenses for that property. And then it will automatically transfer your net monthly income from the previous form, and it'll subtract your monthly expenses from your income. It'll tell you your monthly net income, also known as your disposable income, which is basically just what you have left over each month after you pay all of your allowable living expenses. This number could be a negative. You could be $200, $300, $400 in the negative. It doesn't matter. The broker, the better for Chapter 7. So it doesn't matter if it's in the negative. You don't want it to be like $2,000 in the negative, because it doesn't make sense, because it's supposed to be what you're currently making and what you're currently spending. So, to be $2,000 in the negative just is not correct. It's a little weird. So, next form is Schedule J2. This form you rarely ever need. This is if you have a spouse and you're still together, you haven't broken up or anything, you're not legally separated, you're not separated at all, you're still together, but you're living in separate households for some reason. Maybe your spouse is working out of town and has their own household. If that's the case, then you would have to list a separate, Schedule J for your spouse's household. Otherwise, you don't need it, and that's why it says not used unless it's applicable. Summary of your assets and liabilities. This is basically just a summary of all the stuff that you've already filled in on the previous forms. The software will automatically fill this in for you. You don't have to fill in virtually almost anything on here. And a lot of people say, can I just get the free forms off the court's website and fill them in? And you can. It might take you a week and a half to do it, but most people use automated software because there's a lot of forms to fill in. And you see here there's a lot of forms. You don't need all these forms. You need some of these forms. You need a lot of these forms. But it looks like a lot of forms, but most of these forms take 2 seconds, 10 seconds, or a few minutes to fill in. 10 minutes, 5 minutes. So it doesn't take that long. You can probably fill all these forms out in a matter of 45 minutes to an hour and a half. So it doesn't take you that long to prepare your own bankruptcy, especially if you're using automated software. If you're using free forms that are not automated, it might take you a week and a half to do it. So next one here would be declaration about an individual debtor's schedules, and this is basically it'll ask you in the voluntary petition, it'll ask you here again, did you pay or agree to pay someone who was not an attorney to help you fill out your forms? Yes or no? If yes, then you type in the name of the person that helped you, and down here it'll ask you, basically it'll say you're under penalty of perjury. You're basically declaring that the summary and schedules that you filled out are all true and correct, and you sign it. And then this statement of financial affairs is 28 questions that you have to answer. Actually, in my experience, only about 5 or 6 of these questions, if that, are applicable to most people. Most of them you just put no, 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 no. So, and just to give you an idea, it'll ask, here's one question, what is your current marital status? Are you married or not married? If you've lived at your current address for less than 3 years, it'll ask you for your residence, where you've lived for the last 3 years. It'll ask you for your gross income, for the last 2 years, plus how much you've made so far this year, like your gross, which you can usually get off your last pay stub, your year to date, and this is wages or business expenses. If you have business income and you're also an employee, you'd combine them and put the total here. You do it for the current year to date, how much you made so far, and then the last 2 years, which you get off your W-2s or taxes or something. And then this question will ask you how much you've made, did you receive any income from any other income other than business or employment, like, for example, Social Security, alimony, child support, something like that. Any kind of income they call unearned income. And you just go through here and fill them out. Like I said, most of these do not apply to you. In most people, in most cases. Next form would be Chapter 7, statement of, I think we missed a form here. Actually we did not miss it. It's right here. Statement of financial affairs. Oh, that's the one we just filled out. Sorry. Statement of financial affairs, it would be statement of intention. Okay. Statement of intention is for, this form will basically just ask you what is your intention with regard to any debts that are secured by collateral that you've previously listed on Schedule D, like David, like your mortgage or your car loan. It'll ask you, what do you want to keep your house, or do you want to retain it, or do you want to surrender it to the creditor and just wipe out any further liability on it? If you check the box that says surrender, then after your bankruptcy is over with, then your creditor could, start a foreclosure or continue a foreclosure if they're already foreclosing. You're not going to have to surrender it immediately. It may be 2, 3, 4 months down the road, and they still have to go through the foreclosure process or whatever process, a deed in lieu or whatever. But if you check that box, that means you don't want to keep the property. You're not going to keep making the mortgage payments. And here, if you want to keep the house, keep making the payments, then you just check the box saying you're going to retain it and enter into a reaffirmation agreement. A reaffirmation agreement is basically just a standard form. It's called a reaffirmation agreement. The creditor will prepare it, and they will basically put the balance that you owe, and they'll send it to you to sign, and you send it back to them normally, and the creditor will file it with the court. Once it's filed with the court and approved by the court, then that debt will essentially be excluded from your bankruptcy. You just keep making your payments and keep the car if you want to. And here is a automobile loan. When it comes to personal property, which is anything other than real estate, you have a third option. You can surrender it, you can retain it and reaffirm the debt, keep making the payments, or you can retain it and redeem it. Redeem means that you're basically, let's say for example you owe $12,000 on a car, but the car is only worth $6,000 for some reason, whether it's depreciated or it's damaged or whatever. You can basically buy the car for the fair market value, whatever it's in most districts, it's whatever the car is worth, the fair market value on the date that you file bankruptcy. But you have to do it in a lump sum payment. Roughly in about 45, 50 days after you file bankruptcy, you have to pay them cash for that amount. So instead of paying $12,000, what you owe, you only pay what the car is actually worth. And that would wipe out any remaining balance, and they would have to give you a clear title. You don't see a lot of people doing redemptions in Chapter 7 because most people don't have a lump sum, cash, like $1,000 of cash laying around, unless they can borrow the money or use their tax, refund or something. So that's what that form is. And then the next form is Chapter 7, Statement of Your Current Monthly Income. This form is a little confusing because the Schedule I form that you previously filled out, that is your current monthly income. That's what you're currently making. This form, which is called Chapter 7, Statement of Current Monthly Income, is not really based on what you're currently making necessarily. It's based on what your income has been over the last 6 months, your 6-month average, which, you could have been making $100,000 a year over the last 6 months. Maybe you lost your job. You may not have any income now. It could be a zero, but you still have to fill in your 6-month average anyway. If your income has changed and you no longer have this income, then the court will basically disregard this. The trustee will basically disregard this, and then they'll go to your Schedule J and see what you're currently making. And so this form will just be filled out for really no reason whatsoever. So it's kind of a weird form. So here you would indicate what your marital status is, married or not married. If you're married, then you have to check the box saying that you're married, you're separated or not. If you're separated, then you do not have to list your spouse's income on your bankruptcy. And just to go back here on Schedule I, which I may not have mentioned, when you're filing a bankruptcy, if you're married and you're not separated, you have to list your non-filing spouse's income on your bankruptcy in this column over here. This is your monthly income. If you're married and you're separated, then you do not have to include your spouse's income. And you don't need a legal separation decree. Just if you're living separate and apart for whatever reason, except for that if you're just doing it just because of the bankruptcy, then if you're validly separated and living in separate households, then you do not have to include your non-filing spouse's income. Otherwise, you do. And the same thing on this Chapter 7 Statement of Current Monthly Income. If you're married and you're not separated, then you'd have to fill out this column B listing your non-filing spouse's income. Otherwise, you'd leave it blank. Or if you're not married, you leave it blank. So here on line 2, you would take your income, your gross income, before any payroll deductions, whatever you've made in the last 6 months, excluding any income for the month that you're filing in. So you take the last full 6 months, you take all your income, all your gross income for the last full 6 months. Let's say you made $20,000. You divide it by 6 to get the monthly average, and you'd put it right here. So this is the monthly average over the last 6 months. And you do the same for any other income. If you have alimony or business income or rental income or any other income, you do the same thing. You just fill out here unemployment, pension, retirement. On this particular form, by law, you do not include any Social Security income, any income that you receive from the Social Security Administration, disability, retirement, whatever. You do not list on this form. You do have to list on Schedule I, as I mentioned, but not on this form. So it'll automatically do all the calculations here. It'll total up all your gross income, including your non-filing spouse's income or your spouse's income if she's filing with you or he or she. And now it'll multiply it by 12 to annualize it. So now if you've got a gross income of $55,920 a year based on your 6-month average, now you'd come here and you just select from this drop down your state and the number of people in your household. In this example, there's a single person with one dependent. So we've got 2 people, and so when you fill this in, it'll automatically it will pop up right over here, the median household income based on a 2-person family in the state of California according to the U.S. Census Bureau. If your income right here is not higher than the median, then you're all done. You just check this box saying that your income basically is not higher than the median, and you don't have to fill out this long means test form, Form 122A-2, which is another form. I would estimate, in my experience, that only about 80 to 85%, or actually about 80 to 85% of people filing Chapter 7 are exempt from having to fill out the means test because their income is not above the median. If your income is higher than this amount, if it's higher than the median, basically you check this box right here saying my income is higher, and then it'll say fill out the means test form, Chapter 7 means test calculation form, which I'll show you in a minute. If not, you check this box and you just sign it and you're all done. You're exempt from filling out the means test unless you have a high income. Even if your income is higher than the median, it doesn't mean you don't qualify for Chapter 7. It simply means that you have to fill out the Chapter 7 means test calculation form to determine if you qualify or not. Most people who fill out the means test form end up qualifying to file under Chapter 7 anyway. So you just have to fill out the form. And this is the Chapter 7 means test calculation. Basically, you do the same thing. You list your income, your gross income over the last 6 months, and then you start subtracting all of your allowable expenses. Some of your allowable expenses are based on standard deductions like food and things like that. So you start subtracting all your standard deductions, and some of them are based on your actual expenses. And then by the time you get to the end of this long form, if you don't have more than like $250 left over, of income, then you'll qualify for Chapter 7. So if you have more than $250 left over, then there's a possibility that the trustee could object to your Chapter 7 and say, hey, take that extra income that you have left over, that disposable income, and use that to pay your debts back, or pay part of them back at least, on a Chapter 13 filing. So you could make $120,000, $130,000 a year. It doesn't matter really how much you make on a Chapter 7. What matters is how much you have left over. You can make $300,000 a year and still qualify for Chapter 7 as long as you don't have more than $250, $300 a month left over. And then even if you had $200 or $300 left over, a lot of trustees would not object to your bankruptcy. But if you had a lot left over, 300 or more, then they may object to it, and you may have to file under Chapter 13 if you want to, or not file bankruptcy at all. So this means test calculation form, as I said, is usually not required in most cases. This statement about your Social Security number, basically you just have to list your name, and everything will already be filled in, and then you basically just list your complete Social Security number here, or just check a box indicating that you not have a Social Security number if you don't have one, and any other Social Security numbers that you've used, if any. And any federal individual taxpayer identification numbers, or ITN numbers that you've used, if any, or you just check the box saying that you don't have any. And you just sign it, and basically you're all done. This is the application to pay the filing fee in installments. If you want to pay the court filing fee in installments, it takes you about a minute or two to fill this in. You just put your proposed dates, which should be approximately 30 days apart, for your court filing fee payments. your payment dates cannot be on a date that the court is closed, like a weekend or holiday. It has to be on a date that the court is actually opened. So you may have to move your payment due date up or back a day or two. It doesn't have to be exactly 30 days apart, but it has to be on a date that the court is actually open. This is a proposed order for that application for the court to sign, approving it or denying it. So, and usually they'll approve it. So. And then the other form here is the application to have the Chapter 7 filing fee waived if your income is not more than 150% of the federal poverty level. And here it says not used because on the voluntary petition we selected to pay it in installments. So this form is not used and not needed, and it's whited out, or not whited out, but it's watermarked, not used. And any form that says not used will automatically be excluded when you go to print. So that's pretty much it. These other forms here, this verification of creditor matrix, it's a generic form. Some courts require this, basically just saying all your creditors' addresses are true and correct to the best of your knowledge. Most courts have their own local form for this, or they don't require it. Only a few courts use this verification, so you really don't need it in most courts. But if you do, we've got it here. And these other forms, bankruptcy petition, preparer's notice, declaration, that's if someone who is not an attorney filled out your forms, they have to fill that out and file it. And if you use a non-attorney, to prepare your forms that helped you, if you paid them or agreed to pay them, they have to fill out this disclosure of compensation indicating how much they paid you. Otherwise, you don't need these forms, these two. And then the other one, if an attorney filled out your forms or is representing you in your case, then they have to fill out this form, disclosure of compensation of attorney for debtor, indicating how much they charge you. Otherwise, you don't need these forms. So you need, most of these forms, and then when you're done, and if you purchase the software, we'll give you a list of which forms you need and which ones you don't. So you just go to this print button right here. Just go to this print button, select all when you're done, and it'll select all the forms for printing. You just unselect the ones you don't need. You don't need this one. You don't need the schedule. What you need that one. You don't need the J2. You don't need the statement of exemption for presumption of abuse. That form is almost never needed, very rarely. Chapter 7 means test calculation. You only need that if your income is higher than the median. So we'll uncheck that. You need the statement about your Social Security number. You need the application to pay the filing fee in installments if you're applying to pay the filing fee in installments. If so, you don't need the other one to waive the filing fee unless it's applicable, and you don't need any of these other forms. And that's it. So, and then you just print your forms out. And then also, whenever you file your bankruptcy, you're going to need what's called a creditor matrix, also known as a creditor list. It's just an alphabetical mailing list. So after you type in all your creditors' names and addresses on the previous schedules, you just click this button, Create List. It'll automatically create an alphabetical creditor mailing list or creditor matrix, and you would print that out and file that with your bankruptcy as well. And the bankruptcy court will use that as a mailing list to mail out an official notice of your bankruptcy filing to all of your creditors, whoever you put on this list. And that's pretty much it as far as your forms. And you would basically print out all your forms and you'd sign them, and then you'd take them or mail them to your local bankruptcy court. You'll need photocopies of any pay stubs that you've received within the last 60 days as an employee if you receive pay stubs. Or usually they have like a form that you fill out, like a local form that you say, I don't have any pay stubs because I'm not employed or I'm self-employed or whatever. Pay stubs, normally you have to give those to your assigned bankruptcy trustee at least 7 days before you go to your meeting, that meeting of creditors where virtually nobody ever shows up. But you still have to show up, and you have to bring a photo ID and a social security card or something verifying your social security number. And your meeting lasts about 3 to 5 minutes. The trustee will just ask you for your ID, they'll ask you a few questions, and then you leave and you get your final discharge order in the mail. But as far as your pay stubs, in most, pay stubs, according to local court rules, every bankruptcy court has a website and they have their local rules, posted on their website. Pay stubs either have to be filed with the court in some jurisdictions, or you have to give them to the trustee. So you could call your court clerk and ask them, do the pay stubs get filed with the court, or do I have to give them to the trustee? Or you just look on the local rules and it should tell you there. That is different from district to district. Everything else is pretty uniform throughout all the court districts other than that. And also, you'll need a complete copy of your most recent federal income tax return. Or if you did not file a return, then you just just check a little. You could actually type it up by hand. You write it by hand, or type up just a little note saying, under penalty of perjury, I hereby declare that I did not file a tax return last year for whatever reason. And you give that to your trustee. Tax returns are never filed with a bankruptcy court. You basically give that to your assigned bankruptcy trustee, and the trustee has to receive it at least 7 days before your meeting. Your meeting is called a meeting of creditors, and it's also known as a 341A meeting. It's the same thing. You should receive your final discharge order in the mail from the court that says all your debts are discharged, which means they're forgiven, within about 60 to 70 days after you go to that meeting. There are a few other requirements which are discussed in the detailed instructional video that's included with the Quick File Bankruptcy Form software. And you can purchase the software online at www.quickfile.net. That's QWIKFILE.net.